There's one assertion that he makes in his affidavit that is somewhat curious. He says, I lived in 2 houses, one of which I owned and one of which I held by land contract. Well, the only, as set forth in Exhibit 5 in our motion for summary judgment, the assessor states that Mr. Vance only owned 2 properties in that time period from 2000 forward, both of which were in Jefferson Tax District, which are both lie and are contiguous. You can see them on the tax map. We made that an exhibit to his affidavit. They're contiguous pieces of property within Jefferson District, Tax District, which is a magisterial district. Only those 2 properties. No other properties are listed in the name of Charles Vance. So his affidavit that he had 2 properties, one of which he owned in this time period, doesn't hold water, except, and I can only make this representation to the court, I will be able to supplement it if the court feels necessary. I had my investigator check the record books. There was an out conveyance by Mr. Vance in 1996. So that was 14 years ago. So I guess you could say that within 15 years, as his affidavit said, he did own a property. It was 11.5 acres. It is listed in Laurel Hill Tax District. So, but that was an out conveyance. He sold it in 1996. So I think there is sufficient information already within this record to overcome any suggestion by Mr. or Dr. Vance of his claim of domicile. Domicile is a legal determination made by this court based on the facts and circumstances before it. I would offer one other thing, and again, I don't have the records custodian, then I can supplement it again if necessary. I have provided a copy of this to Mr. Payton earlier today. We've just received it this morning. May I approach, Ron?
Certainly.
I'd ask that this be marked as hearing exhibit number 18 or 19. 19, we left off at 18. The court will note that the first page is a cover sheet from the American Electric Power Company to David Pogue in my office. The second page is a letter from Patty Foreman, custodian of records, saying she's including the records set forth or responsive to the subpoena. The third page is the subpoena that was issued. And if I may read it into the record, Your Honor, the subpoena called for AEP to produce copies of invoices, bills, and or itemized statements for service to Charles N. Vance III at any and all locations in Lincoln County, West Virginia from January 1st, 2005 through December 31st, 2007. And attached there, you'll notice, Your Honor, that there are 2 sets of records. One is for a house identified as 12385 Laurel Fork Road. And if you go to this last, you'll see that there's a set of documents relating to power supply to 12445 Laurel Fork Road. And we've got to call into 911 to find out where 12385 Laurel Fork Road is, but my guess is, Your Honor, we'll find that it is in fact that house that was identified by Mr. Parker as the other Vance residence that he testified he saw at the time of his site visit when he conducted his survey, and that it too lies within Magisterial District 3. So the only information that we were able to glean is that he had no other electric service in his name during the relevant time period from 2005 through 2007 other than those 2 residences. So I think that the record is sufficient for this court to make a determination that, in fact, Dr. Vance, at the time of his election in 2006, lived in Magisterial District 3. And if the court believes that the testimony of Dr. Vance is further necessary, I'd ask that that be taken up before the hearing, Your Honor. I'd like to even try to do it this week if the court were available to do so. So as to avoid the necessity of at least Mr. Ramey having to pay me for my time and what appears now to be 5 days of hearing on an issue that would disqualify Ms. Harless from holding office and thereby rendering the election contest as to her.
Thank you. Thank you, Mr. Chairman.
Just briefly, Your Honor.
Certainly.
First of all, if the assessor says that this property has been assessed in Dr. Vance's name since 2000, then the assessor's affidavit's wrong, because Dr. Vance did not acquire this piece of property that's in on the Waters of Mud River until August the 30th, 2002, when he bought it from Wesley and Joyce Hoffman. And since that was after July the 1st of 2002, this property wouldn't have even shown up on the assessor's books until the summer of 2004. So that's one of the reasons perhaps that not only Dr. Vance might want to appear, but maybe somebody from the assessor's office, keeping in mind that the assessor in Lincoln County is also a $1,000 contributor to the Political Action Committee that we've alleged in our notice of election contest was behind this 800 and some absentee ballot applications. His son was a candidate. The court will hear testimony next week, I believe, that the assessor, from whose office this affidavit originated, saying that Dr. Vance owned this property in 2000, which would be 4 years before it went on the books in his name, visited homes in the Lincoln County area in the company of a man who's a convicted felon, convicted of vote fraud, and confined to the federal penitentiary for the purpose of soliciting from unregistered voters applications for. Those are things that we might find pertinent if we had to deal with other than affidavits. The fact is, I don't know what these power company bills mean. I know what they would mean to me. When I leave here today, I'm going to drive out Route 3 here, Route 19, go to my home in Glade Springs, which my wife and I own jointly, and in which I have utility bill. Now, that's not my domicile. I'm registered to vote, and I transact business, and my office is located in Putnam County, and we live there in a building that's been remodeled into an apartment, which is in her name. Now, what are we going to do if we act on this power company bill today and find out that, well, there are bills for Bertha Vance that have been outstanding for years and years in Laurel Hill? I don't know if there are or not, but I know that's his wife's name. I mean, I just think we're getting the cart before the horse here with affidavits on an important issue. And as far as the trial is concerned, there's not going to be one witness or one exhibit that's offered in the Brumfield matter that's any different from what's going to be offered in the Harless matter. The evidence is, it's all the same. There's not any burden on anybody for preparing for different strategies, different witnesses. The witnesses that we call are only directed to the matter that's raised in the notice. So whether we deal with Dr. Vance first, whether we deal with him last, that's really a matter of irrelevant. The only thing I would say, that I do have one witness who's a handwriting expert, and the only day he can be available next week is on Monday. So if we do take up Dr. Vance Monday, I really don't see how I can do it this week. My daughter's supposed to be induced into labor on Friday. She's having a baby at St. Mary's Hospital down in Huntington. I'm supposed to be over at the Greenboro on Thursday for the State Bar Association meeting of the Bar Fellows. I can cancel that, I suppose, but I don't know what this man's schedule is. He's a doctor. Whether he can, assume he has to have some time to make arrangements. So, well, that's my response.